And we are going to start the morning off with our hearing. And Jan, I just want to confirm you're ready for me. So check.
While we're waiting, I'm just going to say I'm going to stay on mute and I'm going to have my camera off most of the time because I'm home with 2 kids today and I don't want any surprises, but I'll be here and unmute when I need to.
And just have an awareness with the hearing, we'll have a roll call vote.
Okay.
So that's what I'm hoping to hear from Jan. All right. I am What do you think, Tim? Should I go ahead and start? Or you think wait for Jan?
Yeah, I mean, we will need her just a couple minutes into the hearing to address any comments. I don't think that there have been any, but she would be the one to confirm or deny that.
Unmute. Okay, I think I'm here. I think I finally figured out what I was doing. I was muted.
Gotcha.
I got confused between mute and unmute.
It's different than what we typically use.
Yeah. If you guys can hear me, I'm here.
All right, sounds good. I'm going to go ahead and get started. All right, I will now open the public hearing on CAR 6552. This hearing is being conducted in accordance with the Kansas Administrative Procedures Act, CAPA. I briefly want to confirm the process which has been followed as required by CAPA. The regulations, organization, style, orthography, and grammar have been approved by the Department of Administration. The regulations have been approved in writing by the Attorney General as to legality. The regulation, along with the economic impact statement, has been submitted to the Director of Budget for review of the accuracy and completeness of the agency economic impact statement. On November 7th, 2024, a notice of today's hearing on the proposed amended CAR 6552 was published in the Kansas Register, which complies with the 60-day notice required by law. In addition, the proposed amended regulations were submitted to the Legislative Joint Committee on Administrative Rules and Regulations, JCAR, and Kansas Legislative Research Department, KLRD, which reviewed the proposed amended regulation on December 11th, 2024. The committee had no comments on this regulation. In regard to the board's reasoning in seeking to amend this regulation as amended, CAR 6552 will become consistent with board statutes regarding what an applicant must submit to the board in support of an application for licensure. The regulation provides clarity to an applicant who is seeking licensure in this state. In regards to today's hearing, I first want to confirm what will be admitted to the record we are making of this hearing. We will include the notice of hearing published on November 7th, 2024, the regulations stamped as approved by both the Secretary of Administration and the Attorney General, the economic impact statement for regulation, and the report of the December 11th, 2024 meeting of JCAR as described in the Kansas Legislative Research Department, December 17th, 2024 letter. Ms. Murray, were any written comments received relating to CAR 6552?
No, there were not. And
so there are no comments to add into the public record. We will open up the hearing for any verbal comments of any member of the public that wishes to make a comment. Does any member of the public wish to make a comment? All right. No comments to record. This will conclude the introduction of comments from the public. We will now consider board action on the proposed amendment to CAR 6552. At this time, does any board member wish to make a motion to either adopt or reject CAR 6552 as amended, or go to a motion into closed session to discuss the matter with the attorney? So would anyone like to make a motion?
I'll make a motion to move to closed session to discuss.
I'll second.
So in regard to the motion to go to closed session, we'll need a purpose, which is pretty evident, justification. I assume you're wanting to seek attorney-client privileged information regarding the proposed amendment, and then a time period as well.
So I'll make a motion. We move to closed session to have discussion under attorney-client privilege to review the proposal for 15 minutes.
Okay. So we would reconvene probably about 8:25.
Okay.
And so then, based on the motion, was there a second?
That was Dr. Walters.
Dr. Walters. Okay. And then take a vote.
All in favor say aye.
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 Aye. Opposed, same sign. All right, we will be moving into closed session at 8:10 until 8:25.
Jan, do you have a link, or would you like me to circulate one?
Hang on, because I thought maybe they could put us into executive session.
The screen says we're in executive session.
Oh,
Hang on, let me make sure.
And so audio is still on for our public members.
Yeah,
Let them know, Jan.
yeah. I don't know. I'm not getting a response. You want me to set up a Teams meeting real quick, or Tim, do you want to send something out?
yeah, I can send a quick Zoom link to everybody. Okay, I just sent the Zoom link to everybody. It should be in your email shortly.
All right, it is 8:25 and we are coming out of executive session. At this time, does any board member wish to make a motion to either adopt or reject CAR 6552 as amended?
I'll make a motion to adopt CAR 65-5-2 as amended.
Second.
Does any board member have a comment before we go into roll call vote? Ms. Murray, if you will perform the roll call vote, please.
Dr. Bircher.
Aye.
Dr. Nagaraja.
Aye.
Dr. Beaver.
Aye.
Dr. Walters.
Aye.
And Mr. Katz.
Aye.
And that's everyone.
Aye. Ms. Murray has prepared a certificate of adoption of our approval of the amended regulation today, which will record the roll call vote. I will sign the certificate of adoption on behalf of the board. With that, I will officially close the hearing on CAR 6552. The regulation, along with the certificate of adoption and the economic impact statement, will be submitted to the Secretary of State for publication. All right. Moving along. Maybe. Let's just discuss modifications to the agenda. I do think it was a good idea to not be in person for this meeting. Reports on the news today, a lot of the highways are still really bad coming out of Kansas City to Topeka. Quite a big backup on K10 today. So we will be rescheduling the board training that was scheduled for the afternoon. And you can review the other changes made by Jan. Any questions about the modification to the agenda? And Jan, any comments at all?
No, I don't think, no. I'm still hoping to have Office of
All right,
Personnel here, but I haven't heard from them this morning, so I don't know if they're still working from home or still taking off or not. So we may or may not have those.
Okay. Okay. Next, we'll move on to review and approval of the minutes of the last meeting. Would anyone like to make a motion?
I'd make a motion that we accept the minutes from our previous meeting.
Second.
All approval, say aye.
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 Opposed, same sign. And motion is approved. All right, let me check and see who's in our meeting. Is Dr. Abbey available for his trade name application?
I'm not seeing him on the list yet.
I think it's listed to start at 9 o'clock, right?
Yep.
Yeah. So they may. He'll be I believe he'll be appearing with his attorney as well. So they're probably relying on that 9 o'clock time.
Yeah, because I didn't change any of the times because they've already been sent out, so I didn't do any of those. So sorry.
Well, that's true. I don't think you could. I mean, there's a time period to give notice, so I don't think you could amend it without their agreement. So.
Yeah.
Oh, that's fine. I think, why don't we move forward to the report of the president? And I have nothing to report at this time. How about a report of the vice president?
I have nothing to report at this time.
I think you're muted.
Am I still muted?
Just
No.
delayed. Sorry.
Okay.
And how about the report from the secretary treasurer?
So the only thing concerning my report would deal with our process or thought process for allowing hours to be counted towards your opioid course required by the Fed. And we had a little bit of discussion of this at our previous meeting. It's the 8-hour course that we're required for our DEA as to accept part, all, or none of it for continuing education. It's an online course, so that fits within our realm. And I don't have a strong view one way or another. It's a one-time thing. And I'm asking for input from the board members as to how many. I've taken the course. Has anybody else here had to take it yet?
No.
I had to take
My
it
understanding. Oh, sorry. Go ahead, Gina.
Sorry, I don't know why I'm delayed. I had to take it actually shortly after our last meeting. I was all like, I haven't had to take it yet, and then it came up. Is there more than one training? It seems like there
Yes.
might be a couple options, which also makes that a little tricky, I would think. Like, would we have to really evaluate the content and make sure it's the same, or do we take the word?
I'd also like to state there's an option to opt out of the training completely, and you are still verified by the DEA. So, for example, all of the MDs that I work with have just opted out of prescribing opioids, and you're done. You don't have to worry about the 8 hours at all.
Well, but the thing is, as far as opt-in, opt-out, or different courses, that involves any CE that we've got. I mean, we've got CE from a lot of different sources, and some of it may be more relevant than others. So from those arguments, I'm not sure if that changes things that much. Initially, I had mentioned something about giving partial credit for it, and then there was some discussion as to how that might be hard to do. The fact that it's a one-time thing, I mean, Jan, have we had very many people ask to have that included in their CE?
There have been a few, and I've been kind of telling them that, yeah, but it's limited to the maximum of the online courses that they could have.
So
they
we've
may or
already
may not get credit for all of it.
So we've
Yeah,
already given
we
some
have
people
been.
partial credit.
Right.
Then from that standpoint, if we've already given some people credit, I think we either need to make it publicly known that we're not going to, or go ahead and give credit to anyone that applies for it.
So I think before that decision is made, I agree with Dr. Nagaraja that we should be looking at the quality of the education and what is being offered through it. And we need to determine who is hosting these continuing education courses so that we can verify that they're getting the same information and quality information.
So am I incorrect in understanding that those administering the DEA are approving the courses they will accept and not accept? That's how I read it when I had taken it.
I'm not sure of your question.
Well, I'm saying if the DEA is approving the course, do we need to really overwrite what they accept or not accept?
I just have a hard time moving forward with accepting it, knowing that we know nothing about what's given on the test and we can't verify. I mean, I can't even tell you how many, if there's a test you have to take at the end, how many hours it takes.
There's no test.
It does take the actual whatever. So I mean, at least, well, the one I took, you couldn't forward or skip or anything. So you had to have it open. There's no way to verify if you're listening, or there's no testing, like you said. My other thought on it, having taken it and having sat through the 8 hours, I don't find a lot of it super relevant to our practice and what would be quality towards improving us as optometrists. So if we decide to give partial credit, I'm not against that. But for me, honestly, it would be like an hour, because a lot of it, most of it is what is substance abuse? You know, what are the different types? What are the different treatments? What are the different things that people who are dealing with patients who have substance abuse or are at risk for it? And which is important. It was honestly very enlightening, but not necessarily maybe relevant to optometric CE, in my opinion. And, you know, I'd love to get credit because it was long, but genuinely, I don't think the content would be, I wouldn't feel comfortable personally accepting it for, especially not for the full amount. And also, so are we telling people that it is acceptable? Because then we need to put a pin in that, or tell people that we're discussing it.
I guess I was unaware that we had given anybody credit for it yet.
With everything going,
I can't hear you, Jan.
tracker. Oh, am I muted?
Now you're back.
Okay.
There's a little bit of
am I here again? My thought is with the OE tracker and all the hours going through the OE tracker, it's hard for me to tell without actually going through line by line on the OE tracker what's getting credit for what. Once it's in the OE tracker, it's good. And so I don't know how we can curb that with it going through the OE tracker.
How does it even get into the OE tracker? Because there was no scan for it or anything to upload it.
You just have to submit it yourself.
Yeah, you'd have to submit it yourself.
Okay.
And so I don't know, and I could probably maybe go through and look the last couple of years to see if I can even tell if anybody submitted it to ARBO. But that's going to take some time. I just know I've had people ask. Whether or not they actually followed through and did it, I don't know.
Can you verify, Dr. Beaver, that the test is once a lifetime versus every 3 years when you have to renew your DEA license?
At this point in time, what they have published, it's once. That doesn't mean they won't change their mind on down the line. But when I took it, reading through, it was on the DEA site, it was a one-time thing. But that doesn't mean they won't change their mind. And the other thing that I want to point out is, one, I think with changes in the future, we should encourage everybody to be compliant with the level of their licensure. For the state contracts that those of us that take, we're required to have our DEA number to continue those state contracts. I was unaware that you could opt out of taking that and still renew your DEA, because the wording with that wouldn't imply that you could do that, but maybe that's a new twist. I don't know. You said some of your partners had opted out.
Mm-hmm.
Is it? I assume this is not COPE approved CE.
Yes.
No,
Correct.
there are organizations that approve it, but COPE is not one of the ones that they've sought approval for.
Well, do we have the capacity and the ability to analyze this? I mean, compared to a standard that we have for other education. I mean, sometimes we go to meetings where it doesn't seem like, what we're learning is all that relevant. I don't know how we parse this out. Like Jan said, if it's in the OE tracker app, then that's a lot of manpower in terms of going in and parsing that out. Not to say that we couldn't do it, but what would be the mechanism in separating that out if it's showing up in the OE tracker? Is that just administration going in and looking at everybody's, flagging it if it's not COPE approved?
How do we track our other requirements? How do we track that they got enough of the different topics and minimum and maximum? How are those tracked in OE tracker?
Okay, so how it currently works is that once it gets into the OE tracker, and then when it comes into our system, it's automatically downloaded, and there's a thing on the back end that tells you, or the system tells you, translates it from COPE to one of the Kansas categories like farm or general or practice management, and that's how it gets downloaded. Kind of like live versus non-live. They look at all the different versions of how live can be, like lecture, live, whatever the new terminology is. And then when it comes into our system, it's automatically switched over into that. And that's how it does it. It's a program on the back end that does it. So when it downloads into our system, that's why it looks a little bit different from COPE or from the OE tracker, because I'm not tracking COPE IDs at all, other than that's what's needed to translate it into the COPE or the Kansas categories, if that makes sense. Because if you run your OE tracker report versus what the report you run out of our system, that's why they look different. It's that there's a thing on the back end that's switching it over into our stuff, which can change, with the new system coming in next year. That's something that we can look at about changing or updating how it comes across, if it's going to come across straight as what it comes into the OE tracker. Because, way back when they decided that pharmacology was going to encompass everything therapeutic, instead of having all the different SDs and ASs and all those other different classifications that COPE has.
But it sounds like there may be a little bit of a disconnect here to Dr. Walter's point and question earlier. So this would fall under the category of a course that would have to be approved by the board. Your regulation contemplates that the provider is going to submit something in advance to the board to be reviewed and considered for approval. I assume that's not occurring here, and so there's a little bit of disconnect with how your regulation is structured versus, I suppose how this course would be considered for approval on a case-by-case basis.
Our
Does
other
that make sense?
option is, do we submit it for COPE approval? Meaning, do we turn it over to the hands of COPE and see what they assign as classes?
Do we have any idea what that process looks like?
Well,
like
from
a board.
That's hard because it's not our class.
Right.
And so I think that's what we'd have to look into.
Yeah.
If it's your own class, the process is pretty straightforward. But since we are not the host, I'm not sure how that would work.
And then the next question is, does this affect enough doctors within our state for a one-time thing that we go to the effort and energy to do that?
Jan, you don't have a register of doctors that keep a DEA license, do you?
No, we don't, because it's not required. So I don't even put that in when I'm entering the stuff. And so if it's there, it's because they've entered it themselves.
So as it exists currently, since this is not COPE approved, that this needs to be approved on a case-by-case basis. Is that correct, according to the current statute?
Yes, it falls under sort of the residual category in your regulation that it's not put on by the AOA or KOA, college, university. So it falls under the category of a course that must be approved by the board in order to obtain credit.
And we've approved some of them already.
Sounds like potential.
I mean, it sounds like it, but I'm not sure I recall the matter ever being, put to the board for consideration before, unless that occurred before me.
I think we just had a few that slipped under the radar.
Yeah, and it's something new, so it's within the last couple of years. It's even went into effect.
Okay.
I'd say a year, maybe less. Yeah.
So I think our plan should be for Dr. Bieber to continue exploring, number one, possibly contacting the KOA and see if they have any intention in the future offering such classes. Number two, are we allowed to approach COPE and get that to move forward? And in the meantime, the rest of us consider, I do think we need to take away all of the gray, meaning it needs to be a very black and white answer, so that we're not getting in trouble with giving certain people allowances versus others. So I think let's start there, and then we'll table the decision until our next meeting, and hopefully Dr. Bieber will have some additional information for us.
Just another thing to consider, it might be a little confusing for applicants if that's showing up on their OE tracker, and they might feel like they've gotten their hours, when they haven't. So it may be.
Well, and at this point, I don't know if we can take those away. If we, if they're past the renewal stage, but I think at least moving forward, we would know.
Well, for the ones that have already been approved, they've been approved. But.
Yeah. And a lot of people, when they look at the OE tracker, they see non-COPE, they think it's not approved at all. So they think they're not getting credit for it at all. Because I get that email all the time. I just took all these classes and they're non-COPE. Can I get approval for them? So I get, that happens a lot too.
So the fact that we're still quite a ways out from our next licensure cycle, I think we ought to release some notice to everybody that that's not a currently approved course for ours.
I agree.
And so, Tim, I'm so nervous about putting things in the newsletter that have not had a final decision, only because we've had such complications with that in the past. So would you recommend that for this year's newsletter to actually state that no decision has been made, or do we wait until a decision is made before we publish?
No, I think it makes sense, the perspective here that the course has to be approved by the board, and it's not yet approved by the board, right? And so you're letting your licensees know that's the status. And if they're going to rely on that course without board approval, they're sort of relying on it to their own potential peril, subject to a final decision. So, I mean, I think that's the way you structure the notice, that talk about what the regulation requires. This course falls under the category of would be required to be approved by the board. That approval has not been given as of this time, and so you're putting them on notice that that's the situation. Now you may decide to approve it in the future, but as of right now, you've not made that decision. So it's if they want to rely on that course for, to meet their hours, they're relying on it potentially to their own detriment.
Okay.
Do we need to specifically reach out to those who we may have said are approved to let them know about this update? Or is the newsletter sufficient?
So I think that anyone who has already renewed their license, I don't think we can do anything about that. But anyone who has already submitted it and has not renewed yet, they will be notified as of this newsletter.
Okay. Sounds good.
And my approach is going to be that since this is a national issue with the DEA, I'm going to approach the KOA and get the KOA to approach the AOA to see if they, as an organization, can seek COPE approval for this. That's going to be my approach.
Is this something, Jan, that we could send out for an ARBO survey? Or do you know if there's been anything like that?
I have not seen an ARBO survey on it, but I could ask the one to be sent out and see what other states are doing. I mean, that's not that big of a deal. I can do that.
Thank you.
And have the result for the next meeting.
Well, thank you for helping me sort
All right.
through
Thank you,
this.
Dr. Beaver, for looking into that. And I think we'll get some more information and hopefully have a decision by next meeting. All right. I do have Dr. Abby and Ms. Belquist available now. So I'm going to return to the trade name applications. We are almost at 9 o'clock. So before we open up discussion, I just need to verify we have a lot of information in our minutes regarding the Dr. Abby case, and a lot of the information is old or no longer applicable. So Tim, I thought maybe you would review. I don't know if you can see what we see in the board member page.
Yeah, let me, I think I should be able to share my screen and maybe we can look at those together.
So there's been a lot of behind the scenes action, and Jan has added a lot of information as we go along, but things were changed as of January 6th. And so hopefully Tim will kind of verify what we're looking at here.
Are you able to see my screen now?
Yep.
You can?
Yep.
Okay, thank you. And Ms. Belquist, are you on the line? Can you hear us?
I think she's having some technical problems.
Okay. Well, what I'd like to do is try to verify that what we're looking at are the correct materials for the application. But we'll see if we can get Diane here.
Tim, while I can see your screen, is there a way you can enlarge that any?
Does that help, Dr. Beaver? Okay.
Yes.
Okay. Well, we're not going to be able to move forward without Ms. Belquist, but I can quickly go through what I believe the pertinent documents are, and we'll see if we can get her in here. So
I think
the
she's
first
on,
would,
but she's muted.
yeah, I see she's muted. Oh, Diane, I see you now. But so the bottom of your screen, are you able to unmute? No? Okay. I guess we could attempt to use hand signals for this part. So if everybody can see, this is the application that was submitted by Dr. Abby. And the trade name requested, I'll highlight it here if you can see that. Michael Parsons and Associates Eye Care Group PA is the trade name that's being requested. There is an issue that I confirmed with Ms. Belquist. The question here, do you intend to practice through a professional corporation or professional limited liability company? The answer is no. I think there's a little bit of concern about that question, but there is the intention to practice through a professional corporation. And so this is the Exhibit A that they've submitted in support of the application. This is a amendment to the Articles of Incorporation for Kansas Physicians Eye Care Group, PA. It's proposed, and Diane, if the trade name is approved today, the intention is to go ahead and file this document with the Secretary of State, correct? Nodding your head, yes? Okay. And so if you see here, Section 3B of Dr. Abby's Exhibit A, they're proposing to amend the name Kansas Physicians Eye Care Group, PA, to Michael Parsons and Associates Eye Care Group, PA, which is the name the trade name that's requested of the board to approve today. The purpose of the professional corporation would be to include the practice of optometry in addition to medicine, and then ancillary services there too. And then they indicate that the ownership is amended to include Dr. Abby in addition to the prior sole owner, who was Michael Parsons, MD. And have had some back and forth with Ms. Belquist. They have provided a copy of an assignment document showing transfer of an ownership interest in the professional corporation to Dr. Abby. I don't think that that's part of the materials that the board members have, but certainly if anybody has questions of Dr. Abby, Ms. Belquist about that aspect, we can certainly work through those. The other, I'm going to stop sharing for 1 second so I can confirm this is correct. So you do have, the board members do have, and this was sort of I think a previous version of things, but you do have articles of incorporation for a separate professional corporation relating to Dr. Abby. That's not at issue for the purpose of this trade name request. And then there was also a previous amendment form to Kansas Physician Eye Care Group, PA, to a name that was a little bit different than the trade name request. And so, our understanding today is that it's what I've referenced as Exhibit A. I'll share it one more time. But what I've referenced as this Exhibit A here, this is the intent, at least what's been represented to us as far as what the proposed amendment to the corporation's articles of incorporation is in support of the trade name application. And the last thing I'll note that they've also provided, a request for a certificate of good standing for Dr. Abbey, which when a professional corporation is seeking to amend its articles, it does need at least in this fashion, they do need a certificate of good standing from any licensing board that may be related to one of the shareholders' professional licenses. And so they have requested that as well. And if the board would approve the trade name today, my suggestion would be make it contingent on filing the amendment to the articles of incorporation along with the certificate of good standing. That way, those are requirements under the professional corporations law to formally amend articles of incorporation. So I hope I covered a lot of it. If there are any questions, Diane, I don't know if we're able to hear you now.
Thanks, Tim. Oh, my apologies. I was just going to say thank you for the board's patience, and I think I have figured out the technology issues on my end, so hopefully you can all hear me in case you have questions. I'd be happy to answer them.
I have a question on why it was decided in the title to leave MD off of Michael Parsons' name.
Well, that was a election by Dr. Parsons. I would speculate that it is just simply cleaner and simpler name as what is proposed in the trade name application and then what you have seen in the proposed amendments. So I believe it's just probably driven by simplicity.
So I have a small concern that seems slightly misleading to leave that off. So that is one concern. And then how do we move forward, Tim, with confirming, so Dr. Abbey is now an owner and working through a corporation. Do we need to verify that he is paying a lease fee to Stanton Optical, or how do we move forward with that information?
Well, so my assumption would be, and we previously had these documents, been some time ago, but my assumption would be that any lease interest would be through the corporation itself, as opposed to Dr. Abbey personally. I mean, you can ask him those types of questions. I would say, I think if I'm understanding the sort of the tenor of your question, that's making sure that there is a qualified person who's an optometrist for this professional corporation. That's what's being represented, and that's as far as I can tell, consistent with the documents that they've presented. That Dr. Abbey has been made a qualified person, with respect to this professional corporation that is a shareholder and someone holding a license to practice optometry, and that's really the extent of the inquiry about ownership. If there would ever be concerns in the future, that's appropriate for the board to make inquiry of, whether it's Dr. Abbey, a different licensee, the corporation itself, if there ever would be that concern about ownership. But, based on what they've provided to us, that they have shown that Dr. Abbey is a shareholder of this professional corporation.
A question that I have is Dr. Parsons licensed by the Board of Healing Arts in Kansas?
Yes, he is, and we will go through the proper channels of requesting the approval through that board as well. This board is the first stop, and we figured if we get the approval here, then we'll proceed accordingly before filing this amendment, and then both certificates of good standing from both agencies with the Secretary of State.
Another question I have is, I too have concerns as to why you dropped the MD, but since it's preliminary, his name in the in the byline, let's call it, I think it would be appropriate to have Board of Healing Arts approve this before we approve it.
So the statutory authority doesn't require any one agency to approve ahead of the others, which is why we thought we'd start with this agency. We would still request that you provide the approval with respect to Dr. Abby's trade name application. If the Board of Healing Arts, for an unforeseen reason, would deny it, then we would be circling back and starting at square one again and coming through this agency and this board once again.
Well, I understand what you're saying, but I'm saying if it was, Dr. Abby's name there first and associates, I would see us being the primary. And my assumption, and I do not know this, you could also judge it based on who was the larger stock owner of the corporation. I mean, it's just questions that I'm having, and I realize there may not be any statutory thing that says, well, the larger owner should apply first when it's multiple boards, but.
And if it may please the board, I would like to address the concern about the MD not being in the name. We have studied the board's list of approval and disapproved names, and we feel that the analogous position would be with Green Vision Group, in which this board may know Green was the founding medical physician of that practice, which then later became multidisciplinary with optometrists and medical practitioners. And Dr. Green's name was approved by this board in Green Vision Group without having the designation of MD attached to it. So for that reason, I believe that this name should also pass the same muster with the board.
Ms. Belquist, do you think Dr. Parsons would be objective to either dropping the first name or adding the MD?
I don't know. I would have to coordinate with him and his team. I do not represent Dr. Parsons, which is why I don't have the answer off the top of my head.
Sure. And Tim, you're still sharing your screen.
Oh,
That matters.
thanks.
Yep.
No. I'm not familiar with this, so I appreciate you letting me know that.
Any other questions from any board members?
Well, the other thing that I'm also not quite understanding, when Tim referenced the newer information that we have earlier, there seems to be an inconsistency across different forms as to which complete name it is. I mean, he referenced that the name on one application is slightly different than it is on another, and I think there should be a consistency all the way across before we even discuss and go forward with it. In addition to the fact that I would like to see this go through the Board of Healing Arts before we pass judgment on it, because the doctor that we're involved with, his name is not even directly listed in the name.
Yeah, Dr. Beaver, I think maybe we can talk about that. There's a little bit of a timing aspect to it. This application wasn't submitted until I think December 13th, and so at the very least, one of the proposed articles, I think, for Dr. Abbey's, it would be his own professional corporation that preceded the application, and so it's not connected to it. And I won't necessarily speak for Ms. Belquist; she can confirm or deny this, but the other articles that we had, my understanding, at least what she informed me, was the name that they had included. They didn't. It was just an oversight that it wasn't 100% consistent with the name included in the trade name application, and so that's why they supplemented to show that we caught the oversight, we've corrected it, so here are the amended articles that go along with the trade name application.
So I am going to make a motion that we go into executive session to be able to ask questions to Mr. Resner for attorney-client privileges. And if we did that, it is 9:11, and then we would return at 9:30. Do I have a second?
I'll second.
All in favor say aye.
Aye.
Aye. And then Tim, just tell us, would you like to send a Zoom or would you like to wait for the breakout room?
I'll send a Zoom.
Okay.
Give me just a couple minutes and I'll send that link to you.
And then if everyone could just make sure that their WebEx meeting is muted, that would be great. All right, it is 9:30, and we are coming back into session. Just making sure everyone's come through.
You got an echo.
I wonder if it's from my dual meetings.
Yeah, you need to mute yourself in the other.
Gotcha. So it is muted. Is that weird?
Now you're good.
It is better? Okay. So moving forward, I think the question is, would the board
Dr.
like
Burchett,
further
if you
discussion?
stop your video on Zoom, we'll be able to see you again.
Okay. I'm going to add this to my resume. I can do Zoom, Microsoft. So my microphone and camera are off, but I still hear the echo. Do you guys hear the echo?
I don't.
Mm-mm.
All right. I think the question will be, does anyone have a motion? I would make a motion to go back into executive session to have further conversation with Tim Resner for attorney-client privileges.
I'd second that.
All in favor, say aye.
Aye.
What time?
Aye.
Oh.
Well,
Opposed,
hold on.
same
Let's
sign.
before we vote. What time are we returning?
Oh, got you. It is 9:33, and let's return. I'm going to do it 9:45.
Dr. Walters, your second applicable to that amended motion?
Yes, still second.
Okay. Dr.
Oh, sorry. Going back. Do any questions for Dr. Quest before we move forward? No questions? And would anyone like to make a motion?
So I guess I have a question. Can we make a motion to table this at this time?
Is that a request for a motion or is that a question for Tim?
I guess that's a question for Tim, because I would like to make a motion to table this, and I'm wanting to verify that that's a possibility.
My recommendation
Yes, that can you?
would be, this is just my personal preference, that I think with all that Ms. Belquist and Dr. Abbey have done, it would be great to wrap this up today, which means I would rather go back into executive session if you have questions versus tabling it till the next meeting. That is just my personal preference.
And Tim, your response?
Yeah, you can make a motion to table. I'm sorry, my video's not working. I'm not sure what's going on, but can you hear me okay?
Yes.
Yes.
Okay, that motion would be in order if you would choose to make it.
I think there's still some items we need to discuss regarding this trade name approval. Dr. Bercher, are you suggesting we go back into executive session? And I mean, we're already in the discussion.
Sure. I will make a motion to go back into executive session beginning at 9:50 and ending at 10:10 in order to get attorney-client privileges discussion with Mr. Resner. Do I have a second?
Second.
Second.
All in favor, say aye.
Aye.
Aye. But so Tim, are you gonna send a new link because you closed that last one?
We just reuse the same.
Yeah, let me see if I can still use it.
All right, it is 10:10 and we are coming out of executive session. Before we move forward, thank you for being patient. We have lots of questions to discuss. Dr. Abby, I just have one question for you.
Sure.
Are you still there? So on your application, it was noted that you would be the only OD working at this location?
The plan is to have more than one eventually,
And
because to cover mainly like my days off, but not like a full time probably.
And so that hasn't happened yet, is that correct?
No, there's no ODs working there now.
Okay, and do you know if there's a plan moving forward? I know we accepted an application for Dr. Choate in the last 6 months. As an employee of Stanton Optical?
I have not heard that.
Okay.
I think you maybe just misspoke. The question was whether he's an employee of the Kansas Physicians Eye Care Group.
Oh, sorry. Yes, that's correct.
Just for a clear record.
Thank you. All right. I would like to make a motion to accept the trade name. And I need to hold. So Sheena has been kicked out. Dr. Nagaraja has been kicked out and needs to log in again. And we need her for a quorum.
Just while you're holding, I am correct in that if he does add up their optometrist to that practice, the board has to be notified. Is that correct?
Right.
Okay.
Yes, that's correct.
Mhm.
And then Dr. Nagaraja, just tell me when, if you've been able to log back in.
Okay, I'm here. Sorry.
That's great. So I would like to make a motion to accept the trade name application. Ooh, let me get this down exactly. For Michael Parsons and Associates Eye Care Group PA for Dr. Abby. Do I have a second?
I'll second.
All in favor say aye.
Aye.
Hi.
And opposed, same sign.
Nay.
And motion passes. Thanks, Dr. Abby, for being patient. There was a lot to review, lots of questions to be asked, so
I know.
we are done.
Thank you very much.
Thank you.
Thank you, everyone.
All right, let's move forward. I'm hoping Dr. Schreiber is on the line. No, he was scheduled at 9:15. I will give everyone a few seconds to open his paperwork.
Yeah, and I never received a reply when I sent him the hearing notice, so I don't know if he's going to be online or not, but I don't know if we necessarily need him or not.
Right. Does anyone have any questions or concerns with this trade name application? It is another very interesting one where the name of the practice will be practicing under a different LLC.
I did have questions about this one. I want to make sure I followed the paperwork trail on this.
And are those questions for us or Dr. Scheibner?
I think probably general questions. Just correct me if I'm wrong, I guess, basically.
Okay.
So the LLC, let me look at my paperwork while I say this. Let's see. Sorry guys. So Mills Optometry LLC was originally owned by Dr. Mills.
Correct.
And so they have amended that. So Dr. Mills is no longer an owner at all of that, and it's purely Dr. Schreiber.
Correct. Dr. Mills has passed away.
Okay. And so Dr. Schreiber is now the owner of the LLC. And under that LLC is requesting the trade name, the new trade name.
So let me look at his application. This one was tricky because, well, let's see. I think my only question with this one is he has two corporations, the Mills Optometry LLC and the 1619.
Mm-hmm.
And so I that appears to be two separate groups. Let me look here.
Oh, yeah.
So I don't know if we just want clarification of that from Dr. Schreiber. And so the 1619 is not a professional LLC, and it cannot engage in the practice of optometry. So I think we just need on record what LLC Dr. Schreiber intends to practice under.
So is that one of those that you want to make his approval to do it pending to, that I could approve pending to it being a PA corporation? Or do you want to wait until our next meeting?
I don't know, Sheena, will you have other questions for this trade name applications?
I don't know. I guess I'm just not understanding what's happening here with the two LLCs. Like, does one own the other? Like, I'm not, because he lists both Mills Optometry LLC and 1619. So are they both owners?
So Tim, I don't know if you can explain how these are filed with the state a little bit better. I honestly can't answer that question for you.
I'm sorry, I didn't realize I was muted. So, I mean, based on the publicly available information through the Secretary of State, he is the sole owner member of each of those two LLCs. Dr. Schreiber is. But 1619 Investments is not a professional LLC, which is an issue. I think the Dr. Beaver's question earlier, you could consider, I mean, if you find no issue with the proposed trade name, you could consider approval, with the contingency, or at least communicating to him that, if there's any intention to practice through 1619, that, I mean, unless it's a professional LLC, that's an issue, and you wouldn't be approving the trade name, for the purposes of that LLC.
So, I mean, just to make sure I'm understanding, if they just hadn't listed the 1619 LLC on the application, if it had just had Mills and his name, we would have been fine there. But because we have this LLC that's not licensed to practice optometry, we cannot, correct?
Yeah, I just don't know what it means.
Okay.
Yeah, and if he were on here, I think, he might give some explanation as to why that's on the application. I think that he probably was just trying to be complete and, trying to get everything on there, but we can't assume that.
Yeah,
Now,
I mean,
am
I
I
think
correct? Go ahead.
Go ahead.
I just want to know, am I correct in the past that we have discouraged offices from naming their office after a location or city?
I think broader than a city.
Okay.
Jan, is that accurate?
Correct. They didn't want to do like or a big regional location is where they've gotten into trouble. Like they didn't like Kansas Optometry, whatever. Those were, or Crawford County.
County. Yeah.
Okay.
I think we have Wichita Family Optometrist. We can have Lenexa Family Optometrist as long as it doesn't already exist. But yeah, I would ask the board, so are we thinking alike in that we might want a motion to approve the trade name pending removal of 1619 investments from the trade name application?
Right. Yeah. And usually I've seen like Mays Optometry be denied because Mays County, they decided they didn't like that one. So
Yeah, Dr. Walters, to what you said, I agree with that. I think that's where I'm at as well. If that's removed or explained, then it would be okay.
I think we give him an opportunity to either turn 1619 into a professional corporation or remove it from the application. He could do either.
So
yeah, it just doesn't need to be on
in the past, you guys have given me the authority to, if they meet those guidelines, to approve it. So is that where we're at?
Yep, I would make a motion to approve the trade name for Lenexa Family Eye Care under Dr. Schreiber, pending we get a new application with removal of the LLC and or updating the LLC to corporation.
A professional corporation.
Professional corporation.
And specifically the 1619 LLC, not the Mills Optometry LLC.
Correct. Do I have a second?
I'll second.
All in favor say aye.
Aye.
Okay.
And so motion passes. Ideally, Dr. Beaver, you'll update us on the next meeting on the status of that.
Okay.
And our last trade name application is for Dr. Jonathan Riddell. Is Dr. Riddell available in the meeting?
no, he's not, but this was conditionally approved also prior to the meeting with Dr. Beaver. So
Right, so I had a handful of questions for Dr. Riddell as well. And so let me ask those, and maybe Gary, you have the answer to these.
Okay.
One, he has a staff of about 8 ODs, and I just wanted to confirm that those 8 ODs will not be employed under this location. And there was another concern with he has multiple LLCs as well. Let me get you some more specifics.
he's got like Family Eye Care of Bonner, Leavenworth. He's got several.
Yeah.
And yet on this application, he put that he would not be working under LLCs. Sorry, Let me get to this paperwork here.
Yeah, he did not list any. He also, on the application, if I remember right, did list his wife is working there, Ashley Riddell, working at that location is the only other OD.
So I think those the clarification that we need is that he has 2 LLCs filed with the state, and the question of, do you intend to practice or currently practicing under the name of a professional corporation? He put no. So we just need to get that clarified.
Okay. Yeah, because I think he's taking professional corporation as being something else other than what you're asking. So, okay, we can do that.
And I find that has been confused a lot lately. So I'm wondering if we need to reword that question on the application. Does anyone else have any questions for Dr. Riddell that we can send through Gary? And so, Tim, if we change the application, I believe that's a policy. And so we change it and we get board approval, but we don't need to. How big of a deal is that to change the application?
I don't think it's that big of a deal. Whether you want to, provide it to the board, or you could certainly assign a member. I mean, Dr. Beaver routinely addresses trade name issues, so you could assign it to a member if you want to proceed that way. Either would be fine, I think.
Would anyone like to make a motion for Dr. Riddell's trade name approval?
Can I ask a question real quick? I'm sorry.
Sure.
I actually haven't had a chance to look at all his trade names. So are his trade names location specific or just Family Eye Care Center? Like, I'm looking at the website and I'm a little confused as to how this is structured. I didn't know if this was going to be related to the website just says Family Eye Care Center. And I think from the pictures on the offices, they all just say Family Eye Care Center. But are they Family Eye Care Centers of specific locations? And I apologize if this is not relevant. I just want to make sure I understand the structure of this.
I think when they got approved, they were approved with the city included in the name, just to keep them straight as to where each were, but they are location specific for each location that was approved.
And so on the new website, Jan, where do we find the list of approved?
You would ask.
Oh, wait, I found it. I'm good.
Okay, cool.
Right where it's supposed to be.
I don't know. I'm still struggling finding things on the new website myself. I think it's under optometrist trade names, and then should be a link.
Okay, so just to review things that I need to clean up here is we want to address his professional association, the fact that he actually would be practicing within a professional association. And there was another question. Or is that
does he intend his other employees
to
work at this location?
Yes. And I think that we probably, and I'm assuming that everybody is addressing that because they're supposed to, but with anybody that's got a multi-doctor, multi-location practice, it's the responsibility of the doctor and the practice to both notify the board of their practice locations, correct?
Correct.
Okay.
Yeah, and And honestly, that's something that's hard for me to track here in the office. And so I need to come up with a way to track it better than what I do. So I'm still trying to figure that out, especially when it comes to like the eye doctors that have multiple locations, lots of doctors. And that's something I need to figure out here, how to track it.
So I would think, and tell me if anybody else is, what they think about this. I think that we could periodically send out an audit form to the license number itself of where are you currently practicing, and see how that matches our database.
Ideally, that's at least happening when they renew their license, correct?
Yeah, but that's every 2 years.
Yeah, and that's supposed to, and that's not saying that they just don't flip through it and don't bother to update their locations. Because also in our little database is they can actually, when you get into like the practice location, when you're entering your information, you can add multiple doctors there, but you actually have to get into that to do it, and not everybody does. And when they do it, they never update it. And so some of them are like the doctors have retired, died, or whatever, that they're still listing showing at that practice. But the only one that can see that is me. So I haven't been pushing that because, like I said, it's kind of hard to see. And you have to actually have their license number. You can't just type in a name. You have to have the license number to do it. And so it's just a pain. So I'm hoping to get that changed with the new system.
With your old system or your new system, either one, just like you send out a newsletter, can you send out an audit form of where is this license number practicing that they could respond to?
I can do that.
What's everybody think of that?
I think it's a great idea, pending we also have an audit coming up of all of the trade name approvals as well.
Yep.
So.
Yep. Which I've been through what people have listed. I just have not compared it to what's online. If I Googled them online, where would I find them?
And I think the only thing I would request, Jan, is if we do send a questionnaire out, that it would say, one, where are you working? But two, what trade name is it approved under? So we have a handful out there that are working at sites that have a different name than what their trade name approved is.
Yes. Yep. And some are working in the database, they showed their name, but they're working at another location.
Well, that or just like the doing business as thing really confuses me as well.
Mm-hmm. Me too.
Yeah. Okay. Well, Dr. Nagaraja raised the point about this applicant and their website. I think that's something to, looking at that as well, that's something probably to consider, because they do use the name, it's generic Family Eye Care Center. Yeah, they're approved for Family Eye Care Center of a specific location. They're using the name generically. It looks like they break it out sort of at the bottom of their website, but it's not. Yeah, it's not necessarily congruent. So that may be something you consider here too. I don't know if it's appropriate for the audit or separately, but if they're using that name, it's not necessarily a trade name they've been approved for.
And I think that's really tricky because there's a lot more of those out there than we realize.
Mm-hmm.
So I personally would have left that to the audit, unless we just want to address it now while we have this application on the table.
I think, to be fair, leaving it for the audit would be probably more appropriate so that we can make sure we're being fair to everyone.
I don't think there would be a hurt or harm in saying, we're approving this and pending, but, we're going to be looking at cleaning up generalities in the future.
Mm-hmm.
Would anyone like to make a motion?
I'd make the motion that we approve the trade name, pending the clarifications that we've already started as far as, I don't want to say ownership, but I'm getting tongue-tied. Doctors practicing at that location, in addition to corporate ownership, being a professional association.
Do I have a second?
Second.
I'm sorry, I didn't hear that.
Second. Sorry.
Thank you. All in favor say aye.
Can we say again what it is we're voting on? So voting on approving the trade name.
Pending, we have clarification of what employees will be working at that location and a reason why it was marked no under, are you working under a corporation when he has 2 registered LLCs?
Okay. And
so
we're
all in favor. Go ahead.
And Dr. Beaver is going to be verifying all of that.
Yes. All right. All in favor say aye.
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 Opposed, same sign. And motion is approved. That is another one, Dr. Beaver. If you could report back on the next meeting, that would be great.
Yep.
We are ready for the report of the member at large. I'm going to request that we take a break for 10 minutes. And so it is 10:37, and we'll resume the meeting at 10:47. All right, we'll be back.
Love you.
Yeah, love you too. We're on a break briefly.
Oh, okay. I just said love you by accident too.
Well, why is that an accident?
Well, you know what I mean.
Yeah, I do.
Right, it is 10:47. We should be out of recess now. All right, moving along, we are at the report of the member at large.
Nothing new to report.
Thank you. And report of the public member.
Nothing to report.
Thank you. And next will be our legal report from Mr. Resner. And you're muted.
Oh, thank you. I don't have anything to report. I think one thing I would suggest, we've had a number of issues that relate in some fashion to our appellate court case that just resolved earlier this year or earlier last year. I would like to start to work up some of those issues to try to get the board to some decision points to be made. It implicates some of the regulatory frameworks we have in place, regulation review that we've been working on, as well as the trade name audit that's ongoing. It's all sort of wrapped up. My hope would be, to set some sort of process in place, whether they're members who are willing to volunteer to work with me. I could certainly, work something up on my own for the board to address at an upcoming meeting. But I think we're at a point now that the dust is sort of settled following the court case that, it's time to review in a little bit more detail some of these issues and try to get the board to a point where we're making decisions on these issues that have been percolating for a while.
And Tim, I apologize. I thought you were going to do a quick rundown of the JCAR meeting and rejection.
I can do that as well. Yeah, I can do that as well.
And thank you to Jan, who took one for the team at the last meeting, but I'll let Tim go into those details for us.
Yeah. Well, so before I pivot to that, I mean, are there any thoughts about, maybe it's most appropriate to frame it in the context of reviewing, some of the impacted regulations. We also have statutes relating to, practicing, maintaining an office for the purpose of practicing that are implicated by our court case. I mean, if the preference is for me to work something up to present to the board, I can certainly do that. If I have anyone who's willing to volunteer to work with me on some of these issues, I'd appreciate that feedback too.
Do you already have a list, Tim, or you need help making a list, or?
Yeah, I mean, I don't have anything centralized, but I have a pretty good idea of, the issues that we had, supporting the violations that the board found, and then the way it worked through the judicial review process. So, but I can certainly provide that to anyone who's willing to volunteer.
I'd be willing to volunteer to help with that. Dr. Beaver, I think you're muted. Were you talking?
Yeah.
Well, some of that was going to be our training session this afternoon, wasn't it?
Yeah, I think it would have related a little bit to that. Yeah.
And so I think what's frustrating, Tim, is as we approach some of these issues, a big one that the court was hung up on is our statute doesn't say you need a physical barrier floor to ceiling that is opaque with a separate door. Yet when we got to that regulation to update that, it was recommended that we not change anything. So I think there's just a lot of confusion on, what do we change and what do we not change, because there's always a loophole.
I think that's right. I mean, at the very least, setting those types of issues up for the board to review and discuss, I think would be, I mean, it's time, right?
Okay.
I mean,
I'd agree.
it's time that we get these issues in front of the board and start to make some decisions. I mean, we had uncertainty for, a number of years in these areas, as the matter pinged through the courts. But I think we have enough clarity at this point that we can move forward and I mean, at the very least, review your policy and determine, what it is that makes sense in the modern practice today. Makes sense for your licensees and for the public, and whatever those policy decisions are, we can then move forward to craft, language that responds to the modern trends today, whether it's through regulation or it's statutes we propose. But I mean, if we can get that moving forward, that would be, I think, very important.
I think Dr. Nataraja doesn't know how much she's spitting off. So at some point, if you and Tim would like to identify areas and then assign, each board member a clump of those, I think that's reasonable. This is a very long and tedious process, and it is a headache. So it is a lot of work and a lot of very just small attention to detail. So if you choose to assign chunks of that out, I think that's reasonable.
That makes sense. That can be our first task, is to sort of do some issue spotting and determined issues to delve out to different board members. So I appreciate that. So the second issue, what Dr. Bircher was referencing, so JCAR, the legislative committee that reviews proposed regulations, it's in your packet, but they provided some feedback regarding KAR 65-8-4, relating to the first issue that they flagged was the use of the word shall with respect to certain elements in a prescription that would be provided by an OD. And the perspective of the committee was, and there was a comment that I think you all have seen that sort of precipitated this, but the perspective of the committee was that not all of those elements would necessarily be warranted through an eye exam, and so is shall really appropriate where you have a patient that wouldn't need a certain measurement specified in the regulation. I think the response to that, at least my understanding of it, is that'd be a good discussion point. But I mean, my understanding is, and this was not a part of the regulation that the board sought to change. This has been the law for 30 plus years. The shall has been in place, and where it's not warranted for a patient. I mean, my understanding of the practice has been to leave it blank, or to put a dash, or label it not applicable to the patient. I mean, if somebody doesn't have an astigmatism, for example, you're not including certain elements in a prescription, and so you're not necessarily ignoring the shall. It's just not indicated for the particular patient, and I think that's a very logical explanation. My assumption is, and tell me if this is wrong, but my assumption is this is the way the practice has handled the issue for the last 30 plus years. But my understanding, or my interpretation of where the committee was coming from, was that they wanted clarification regarding that issue. Whether it always is a shall, or if there's a different way that the board is suggesting that should handle. I mean,
I thought we added as indicated.
We did, and I think it was struck through the process, right, Jan? Maybe either that was feedback from either the Department of Administration or the Attorney General's office.
Yeah, they wanted to know when it would be indicated, and we couldn't really put that, and so that's why we struck that.
And then if we don't use the word shall, what word do we use?
May.
Yeah, I think the answer to that is it's when in your professional judgment it's indicated. So it's, and I don't know that I mean, you really have two options there. You can come back and clarify, and we can craft some language that is responsive to, that concern, or you can leave it in place with the explanation that this is the way the practice has handled it for the last 30 years. This is the perspective of the board, that when it's indicated, it's a shall. When it's not, you're still indicating to the optician through leaving it blank or a dash, or indicating it's not applicable for a particular patient. But that's the first issue that they raise. So I do suggest that you make a response to the committee. They've requested one. So I don't know what the pleasure of the board is there.
My gut feeling is to stick by our precedent, which is we didn't change it. It's been there for 30 years. Unless anyone feels strongly about changing the wording. Ben?
I think the shall ought to stay in place. I think that probably, one of us somehow or another should have been there to be able to discuss it, and Jan not have to take the bullet, but we didn't see it as as big a deal, and still don't, I don't think.
And so I assume our response, Tim, can be all inclusive, meaning it can address this and the next problem.
Yeah. And so the second was the elimination of
PDs.
A6, yeah, pupil area distance, far and near, striking that from the regulation. One of the representatives that sits on that committee, had a specific experience with that, where, if that would not be in his prescription, he has to special order his glasses online. And so if it wouldn't be in his prescription, then he would have an issue and would have to go back to his OD to have that measurement put in place. And I think the concerning thing that was said was, he questioned whether it was a restraint of trade, which I think is a serious issue to be considered.
I mean, I'm the one that brought up dropping that initially, and it's because of some of the newer lenses require more measurements than just that. And some of the newer lenses, even looking out for consumer issues, shouldn't be sold without those additional measurements. So, I mean, you can put a PD on there just even with a ruler, but that's not necessarily in the patient's best interest. So my recommendation was those measurements should be taken by whoever's selling it and fitting it to the frame, which still helps with consumers. And we get complaints, and a lot of the complaints we get is basically about malfitting eyewear, and potentially that helps reduce some of that if more attention is paid to those who are actually selling the product. And some of those online outfits are interested basically interested in making a quick buck and not necessarily what's in the patient's best interest. So it was from a consumer approach as much as anything. And I think, I would be prepared to explain that before a committee, but that's what prompted that at the time. I mean, when PDs were originally probably put on there, and I realize this reg has been updated, but people were probably driving Model A's also when that technology is caught up. So I think we should bring some of ours up to more current standards, and that's one of them.
The last update was May 18th of 1992 to this particular regulation. It's been a while. I appreciate what you're saying. I mean, I guess the argument that would be made would be it still doesn't necessarily address the restraint of trade concern or the option to the patient. I mean, they express concerns that if, you know, it's not included and I need it to obtain, you know, my glasses, that I'm going to have to go back to my OD. And then there was discussion about, for some patients, the distance they have to travel to go and see their OD, you know, busy schedules, that sort of thing was the discussion. And so, I mean, being responsive to the committee, I think that's the charge, is make sure that we're addressing all of their concerns best we can. And then it's, of course, up to the province of the board to decide how you want to handle that issue.
Because we took it off doesn't mean we're not going to release it. I mean, all a patient has to say is, can you please provide my PD measurement? And that's an easy fix. But I think withholding it is a different situation than always providing it.
But you're by removing it as a requirement, you're allowing ODs to withhold it. ODs would not be compelled to give it by law. And I think the restraint of trade is certainly legitimate, and also I think if you're on this committee and the argument is, well, it's more complex than that, then if I were this person who was asking for it to be left on there, I would say, aren't you then making an argument to have more requirements of a prescription if it's, you know, if there's more ways to look at PD than just a ruler? I think as it stands, you know, providing a PD off of your autorefractor, providing a PD off of a ruler, a quick measurement is sufficient. I think it's as relevant to the prescription as many other things on the prescription. So I understand, you know, that striking it from the rule is controversial.
Let me ask this, is there a solution? Because I think all the points that have been raised are good and valid. Is there a solution to address, you know, Dr. Beaver, the concern would be, you know, when the optician actually goes to fit someone, you know, they're in a better position to do it than you are because they actually have the material, right?
Well, because the patient's actually wearing the frame. I mean, I have patients, I put more on the prescription than required as far as lens types and designs, and because I want it filled the same as if it was being filled in my office, because the perception is I've had patients come back say, well, I spent money with X, Y, and Z and I can't use them. And it's not the prescription, it's the patient's out money. In addition to the fact, I've had patients think that I screwed up the prescription because I wrote it down and they can't use it. And it's a matter of when you get the right thing fit properly, it's not the perception that my prescription was screwed up. It's the final job of how it should be done was screwed up. And so then you've got a patient that's out money trying to get a refund from somebody else, in addition to the fact that it's in question as to who's at fault. And I've had that personal experience, and the consumer complaints that we deal with, sometimes that's what we're dealing with those as well. So based on how the frame fits, whether it's a wrap, which type of progressive and some things, those are things that are basically done by those consuming or being paid the money to do that at the time of fitting.
So, and I've never had the pleasure of this experience, but I mean, so I assume the optician would be bound by your measurement and the prescription. And
yes,
so then
so if they need a different measurement that's more accurate than just saying 60 and they need individual ones, you know, it's a matter of, okay, are they changing my prescription, which is really a moot point, but they are. So the thing is, you know, it's in the patient's best interest if they've got something more accurate based on the fit. There's some prescriptions that would never make a difference. It's your more expensive lenses and some other things where it starts affecting that. But I just think that that's something that should be updated, and to be able to do some of that properly with some of the lenses, you need the frame actually on their face. I mean, whether it's a handheld computer or the computer I've got in my room, it sits there and scans that while you're on it's on your face and gives a better outcome.
But I think there's many cases. I mean, I think we all know that a lot of this commerce is happening online. And I think in many cases, it's in the patient's best interest to have something rather than nothing. Because if they have nothing, then.
So if it's happening online, we still have a responsibility for a patient being properly treated. And even with whether exam components or other things, we're already in doubt of, okay, if you're doing this online, are you doing a good enough job? This is still that same argument.
Is the practice been that the optician has some level of discretion to deviate from your measurement, or if say the measurement isn't right based on the specifics they require in their lenses, do they then have to return to the OD to have the prescription adjusted, or does the optician have the discretion to adjust it? I mean, because that's at least part of the issue.
They're supposed to return. They don't have a licensure to adjust an OD's prescription. That would be like saying a contact lens vendor would have the ability to substitute a material or something.
Well,
so I would tell you in my practice that the patient is always getting a more specific and more accurate measurement in the optical that I am not able to perform in the exam room. So we have both regular pupillometers, but we also have an iPad that will scan your pantoscopic tilt, your PD, your lid placement with your pupil. And so we do give our opticians the leeway to use the more specific measurement, because my measurement is going to say 60-63 and their measurement is going to say 62.85, which is relevant in the world of digital lenses. So
but that's still in your office. That's still in your office, so you're not really giving them the leeway, because you're still, if they bring you that prescription to sign, you're still signing it.
But if I sell a pair of progressives in my office to someone who got their eye exam somewhere else, we're going to check the monocular PDs on that, because if a remake happens, that is going to come back to us.
But your office has a license to do that, where if they walk into a corporate entity that doesn't have a doctor, they're not entitled to change a script.
I guess what I'm saying is that having the PD on there doesn't preclude someone at the point of sale from making a judgment necessarily.
It's in the same statute that the prescription part is, so it does.
Yeah, I remember having this discussion when we did. I just think I think for consumers, it probably does cause more problems than it solves, if we're being honest. I think that if you have a lot of people who are getting their lenses online, and if they don't have a PD at all, then they're going to estimate, or they're going to measure it themselves, or they're going to go from a previous one. They're going to be resourceful and figure out how to get their glasses ordered. And I think there's going to be more disenfranchised patients by not having that on. But I do think that it's a matter of opinion. I don't disagree with what you're saying, Gary.
I would think that if your iPad could sit there and take their measurements, you would think that the online people would be able to take the same measurement.
Yeah, but we're putting that burden on the consumer in a way.
I think we're actually putting it on the people that are doing business to do a quality job and protecting the consumer. And I understand what you're getting at, but there are some schlock places that are looking, they could care less whether it fits. They just want to charge their credit card and get it out the door. And I think part of our job is consumer protection from that standpoint. Because I've got some people that they were done wrong and they never got their money back.
I think that's going to happen regardless.
Well, is there a potential solution here? I mean, I guess ultimately you're looking at two different public interest perspectives, and there's validity to both. I mean, I can fully appreciate the providing some kind of discretion to the optician. I mean, is that within reason, right? I mean, is that an option? I don't know if anyone else does this, any other jurisdiction, but I mean, if you do provide the PD measurement and some level of discretion to the optician, I mean, is that in and of itself? I mean, for those that need the measurement to initiate an online order, but still provide the optician with some discretion to adjust it, based on the specific of the lenses or frames. I mean, is that a reasonable solution, or is that creating more issues than it's worth?
I feel like we don't have authority over ABOC accreditation. I feel like that's digging ourselves in a deeper hole.
And I think Jan said last time that half the states have it on there and half the states don't of those surveyed. Is that right, Jan?
Yeah, but it's been a few years since I did an ARBO survey. I can send another one out if you'd like on what they require for contents of a prescription. For an eyeglass prescription, if you want.
I don't know if that'll change much or not, but.
I mean, I can tell you it's mixed for sure, just based on living in other states and conversations with optometrists on forums. Like, it's very mixed. There's some who require it and some who don't. It's all over the place. I think for me, if we're going to respond, if Dr. Beaver feels comfortable helping craft that response, because I think you have a grasp on how you would have that conversation. For me, I think it's worth it to try and respond. And if they keep pushing back, then maybe we have to backtrack on that. But I think it's at least worth one response. It's a very complicated issue that I don't think is very applicable to a lot of other aspects of medicine when you talk about writing specifics for a medical device and then fabricating that device. Because, I mean, the argument can go both ways. If we say that PD can be determined online, then they could say other things could be determined online. But also things that we offer in office for quality control, like making sure patients are an appropriate size and fitting of frames, is not being done online. So that consumer protection aspect is there. It's very challenging. So for me, I think it'd be worth it to have, again, if you're comfortable, Dr. Beaver help craft a response to that particular aspect and see how it goes if other people are comfortable with that.
And I can help with that. My other question was something that was a little interesting, and we need to respond to the committee, and I get that, but was I correct in that this committee, while it reviews it, doesn't have authority over that decision? Was that correct?
That's correct.
So I think they deserve a response, but yet they're not a thumbs up or thumbs down for us doing what we do.
Yeah, that's true. I mean, it is. I would tell you that's something you definitely need to pay attention to, and give the due respect that it's deserved. They don't have the ability to necessarily change what you do, other than if it is a big issue for legislators, they certainly could enact a change in statute. That would be their control. They could enact a change in statute which puts that policy, whatever it may be, in place.
This is a perfect place for PD shall be included as indicated. Yeah.
There you go.
I also think And if I may share one more just opinion on this matter, I think if you're going to say PD is not required, we're going to have complaints to the board that say my optometrist won't release my PD. Now, and we can point to a statute to say that that's not required, but again, it can look as though, you know, as Dr. Gilmore said in his letter to the board, you know, it can look anti-competitive, you know, from our standpoint. And, you know, that argument is not incorrect, that we would be making it, you know, giving in-person dispensers, which most of us are, an advantage by not releasing the PD. I think that argument is valid. So the outcomes here may be, you know, once again, that we're dealing with complaints from the public, where a simple, you know, sharing of the PD would solve the patient's problems in many instances, probably more than it would cause problems to share the PD.
Now, the PD, would the PD be considered part of their medical record? So if a patient requested it, they would have access to it in that sense? So it wouldn't have to be required on the prescription, but if a patient requests it, then it needs to be released.
Great point.
So the other question I have here, and maybe I'm getting a little off topic, but I think this enters in. I mean, we all talk about readers or this and that. Those are prescription lenses. There aren't PDs given for those. We don't regulate those. There's nobody that does. So, I mean, that's still in the same ball of wax.
They're not prescription though.
Okay.
So I think the second part to this is, you know, what's the pleasure of the board as far as we pulled the regulation, didn't move forward with the hearing. It was set for today, but we pulled it so that we could have this discussion and the board can determine what to do. And so that's the second part is, you know, we have two concerns raised by the committee, the use of shall, when it may not be indicated in some situations. And then the second is removal of the PD measurement from the regulation altogether. You know, that's at least what you previously approved. Does the board want to change, you know, the amendments we made? We would need to restart the process, you know, back to the Department of Administration, then the AG, and so on. And ultimately, it'll arrive back at the committee if you materially amend the regulation before you can have another public hearing to promulgate the regulation formally. But, you know, in regard to what you previously amended, does the board want to change it, make some sort of modification, or if you do not, you know, we do need to make a response to the committee. But if you do not want to make a change, you know, Jan, we probably need to renotice the hearing because that hearing date wouldn't be valid anymore. But otherwise, you know, you would be clear to proceed with a public hearing on the, you know, what you previously passed through the process.
My gut feeling is there has to be some sort of in between where we can amend what's already there instead of completely removing it.
Am my understanding on the word shall, like we worded it as like this can be included, but by definition, they're saying it must be included. Is that where the disconnect is, or?
Yeah, I mean, the regulation says, you know, the 6 measurements identified shall be included in the prescription. The 6 items shall be included in the prescription. And I mean, that's, you know, you can get into a little bit of legal interpretation there, but more often than not, it means that you must do it. And, you know, my understanding of how that's been handled, if it's not indicated for a patient, I mean, you tell me, but you leave it blank, or you indicate that it's not applicable for a patient and move on, which makes perfect sense. I mean, that's within the realm of your.
Can we change that to may?
Yeah, I mean, if you do, it's no longer a requirement of your licensees. I mean, there is that element of, you know, if it is a public protection issue, or, I mean, I think the middle ground is, you know, along the lines of when indicated. I mean, I think the question that, and I can't remember if it was administration or the AG, but I think the question is, when is it indicated? It's when it's indicated by your professional judgment. And so we could certainly make that clarification. If I don't know that it's that big of a concern, but we could certainly make that clarification if it's not going to pass through the process.
So I guess I'm kind of stuck where we're actually at. I mean, I know what you're saying, but it's pulled for right now, correct?
Right. We didn't move. It was noticed for, so there's a requirement to provide notice to the public of the formal hearing on the regulation, similar to what we had for 65-5-2 this morning. Notice for today, we pulled it due to the concerns raised by the committee. If you want to proceed with the way it's been amended, you know, as approved previously by the board, we would need to renotice a public hearing. And there's a 60-day requirement, so it would need to be 60 days after the date that notice is published in the Kansas Register, and you could proceed that way. If the pleasure of the board is to amend the regulation, it's likely going to be a material amendment, which our statute would require then that it be resubmitted through the process. So it would need to JCAR before you could then notice up a public hearing on whatever form of amended regulation it would be at that point.
So Tim, does this committee usually respond to the response?
They certainly can. They certainly can. I mean, you know, I don't know exactly how to read their attention on this. I mean, they seem to devote a lot of attention to it during the hearing, and so maybe it is an issue that they would want to respond to the board. I don't know.
So I don't think we should forward it at this time. I think we should give a response, but I don't know that even as a board, we're prepared for how we think it ought to be. So if we strictly give a response to them at this time and then table it to a future meeting, does that accomplish what we're after?
Yeah, I think so. I mean, you could certainly, if you want, we need to make the response, and you could certainly, you know, if you'd like, you could assign to 1 or 2 board members to review and try to see if you know, after your review, there's any changes that they recommend, or if they recommend we move forward, then
because I
that's
guess
ultimately
what I'm at, this is a small piece of stuff that I feel like exam wise and everything else that we need to update. This is just a piece of it. So is it something we could update this as we update other examination components and things like that?
Yes. Mm-hmm. And if you want to proceed that way, I think it makes the most sense. You know, we don't then proceed with a hearing on the regulation as it's currently, you know, been amended by the board for final hearing. I think you just pull it completely and work on changes to the regulation. You would be looking at other aspects in that case, and then you would do it as part of a, I assume some kind of a package, right, with other regulations.
That's what I'm thinking. Instead of a nitpicking, it's kind of like this is part of a bigger picture, and it's not that we're nitpicking on any particular item for certain reasons. It's part of a bigger picture.
So let's move forward with drafting a response. Tim, will you start that?
Yeah, I can work with Dr. Beaver on the response to the committee.
And then we'll table the actual changes to the amendment included in our other future editing that we'll do.
Okay.
Is there anything else from you, Tim?
No, I don't think so. I appreciate the feedback, and we'll get going on those two items.
All right. Report of the executive officer.
So I only had one thing, and Allison Conklin with the Department of Personnel Services has been hanging on graciously online. So hopefully she's still with me and listening. So she can explain to you the process for how my position gets posted and hiring somebody new, because this is all new to me because I haven't done this at all other than when I started and it was already done. So Allison, are you still listening, hopefully? Or do I need to email you? Because I know she's hanging on, been graciously. Let's see if she's. Because I'm not sure. I did post the position description online for you to review, which was the same exact position description that was posted when I had the job. I just shot her an email, see if she's still around listening. But like I said, it needs to get posted. We thought we would post it around March 1st, have it open until filled. I know I have a group of like 5 people that have told me they're interested in applying. Whether or not they actually qualify for it, I don't know, but I do have a list of those that tell me they might be interested in it. Like I said, I'm still waiting. I know she's online, but I don't know if she's listening. The other things that I didn't know if you wanted me to start putting feelers out is if we hire somebody that's in Topeka that wants to move the office to Topeka, do you want me to start putting feelers out for the Office of Facilities, finding us a new location in Topeka in one of the state office buildings? There should be some openings coming up with the new docking building. Agencies will be moving over to docking. So I don't know if that's something you want me to start looking into now or wait until we hire somebody. I do know that the landlord came in right before Christmas and delivered Christmas presents to my office mates with rent increases. I did not get one yet because we pay our rent yearly and we pay it in July. So he didn't give me one yet. So I imagine the rent's going to be going up. I don't know how much, but and in case you're curious, currently we pay $4,800 a year for rent in the office. The other thing coming up due with the office is my contract with the internet and phone services expires in April. And if we don't renew it, then it's going to be an increase of at least $30 a month. And but if we do renew it, it's like a 3-year contract that we'd be responsible for the entire amount left on the contract if we had to break it. So, and I was thinking we would just probably hold off doing that until we knew what was going on with the office.
So Jan, if there is a discussion about moving this position to a work from home, is that the board's decision? Is that the state's decision?
That is the board's decision. In fact, I have out there, Department of Admin has came out with a policy, which I've kind of adopted, as to if you work from home, you know, what kind of a situation you have to have a specific room in your home for this office. It has to be, you know, separate. And I can forward you that too, because like I said, Department of Admin, when COVID hit and people were working from home, Department of Admin came out with this policy of, if you're going to work from home, these are the policies that you have to have, you know, all this. But, and I've kind of adopted it. I don't work from home that often, so it's not that big of a deal for me, but it might be for someone else. But yeah, that's a board decision if you want. And I know somebody that's interested in my position that does want to work completely remote. But, you know, and I told her that she'd have to take that up with you and see if it worked. And Allison, are you around yet?
Does completely remote
Yes.
mean even for the board meetings they wouldn't come in, like these?
Yeah, they would probably show up for board meetings. And it looks like Allison's online.
I am. Can you hear me?
Explain to them the process of how the position, how to post it, and how the, you know, all the good stuff that comes from your end that doesn't apply to me.
Okay. Absolutely. I'm glad. Thanks for having me here. I'm Allison Conklin. I'm with the Kansas Department of Administration, Office of Personnel Services. My official title is HR Manager, and I help lots of boards and commissions, much like yourselves, accomplish things because you've got a huge staff of one. And so it's pretty impossible for one person to know all the HR stuff. So for this position, what we would want to do is request approval to fill it. We have to go through a process. I can share with you what that form looks like because I've drafted something already for you. Oh, I don't think I've used this software before. What does the sharing function look like? Oh, I see it down at the bottom.
Yep.
Okay. Now it's looking more familiar. I think this is it. Okay, can you see the screen?
Yeah.
Okay. So this is the form, this is a draft of the form that we would use to request to fill the position. I put in some language that I took from when Jan's position went to the unclassified service. And so this can be revised any way that you think that it needs to be. The information that I don't have is how much you want to pay this position. If you just want a flat amount, or if you want to do a range, you can. There's right now, Jan is making $26.17 an hour. So, you know, that can be the top end. If you want to do a range, say from, I don't know, whatever you want to do, 25 to 26, or it's entirely up to you. What we send through and get approved, though, is we'll have to go through the budget office. And if they approve it, that would be the key. Does that make sense? Okay. All right. So if for some reason we decided to bump this salary clear up to 100,000 or more, we would have a different form that we would have to fill out and request. But I don't think, I'm going to guess that that's probably not the case. So this is the form that we would use. And then what happens is once we get the approval to fill the position, then we advertise it out there through the SHARP system. and we can link it to your website. We can send it anywhere you want to so that it's seen by the appropriate people, and we can post it for 7 days, 10 days, open until filled. And then once you get some candidates you want to start looking at, then we can get you scheduled for some interviews, and you get to select that top person. And we do reference checks, always do reference checks. I know some people feel like, it's, they're just going to say nice things. Well, that is true to an extent. But I'll tell you, one time I had a coworker for this woman tell me, he said, she's a real go-getter. She really gets after things. And I just don't understand why management is so frustrated with her all the time. Big red flag. Yeah. So he didn't say, so it's good to do reference checks. Yeah. Well, okay. So what questions do you have?
So at the bottom of this form, there is a statement of, let's see, comparable pay. Is that for comparable jobs within the state?
Yes. And that would be specifically in the classified service.
And then will we get a number for that?
No, because it'd be within your agency and you don't have any classified positions that match this position.
I was thinking it would be comparing to other boards, what they're paying administrators. So
I can get you that information if you would like to look at that. Absolutely. Yes. Okay. Do you have any specific agencies in mind, or?
Probably the Board of Dentistry.
Okay.
Any others that you would recommend, Jan, for an executive director position?
I mean, I would say any small agency, if you don't mind. Can I go that route, Allison, or is that too broad for you?
Well, it might be a little broad because some of those agencies have as many as 200 people.
That's true.
Members.
Like barbering is one, because I know they're small.
Yep.
Dentistry. What else has got?
To look at
the real estate appraisals office, because I know she's small too.
Yes.
If I'm thinking of Sally, right?
Yes.
Yeah.
And that's advertised right now. Well, her assistant
is
not hers, her assistant.
Okay. I was gonna say hadn't heard she was retiring yet. Accountancy just filled.
Yeah, there's a board of accountancy. So that might be, they've got 2 or 3 staff members, but you're kind of unique, Jan.
I would say we could throw out there the board of hearing aid instruments, but I think he's way too small.
How big is the vet board?
Yeah, the vet board.
We can do the vet board if you like. I think there's like a 3-person office. Mm-hmm.
Yeah. I'm just trying to think of the ones that come to my small agency meetings that I know are tiny.
Okay. And somebody else started to ask a question and I didn't catch it. No? Okay.
No.
I think those are good.
Do you know I put in the budget, I think when I redid the budget for 25, and I think I did it for 26, I think I put $30 an hour for my replacement, just to be able to like put a number in for something. So
very good.
But that's just what I did in it. And because I've also had people tell me that they have to make more than what they're currently making to take my position too. So
how about the Board of Mortuary Arts, Jan?
Yeah, that was the other one.
Okay.
Is pharmacy small?
They have a staff of 12 to 15. So while they are small, they're not as small as these others that we've mentioned.
Yeah,
They might
they
even have,
have. I thought about cosmetology too, but they have investigators and.
yeah, they have a pretty good sized staff.
I think that's
Um,
plenty for us to get a
okay.
comparison.
Yeah.
Okay, great.
Yeah.
Very good. Okay. So,
So once,
go ahead.
I was gonna say, once it gets posted, then what?
Yes, then we would need to set up interviews. I don't know if you have a subcommittee that's going to be the search committee for this position, or if you are all going to be on the interview team. That takes a lot of coordinating schedules, and we can do that, absolutely, if you all want to be on the team. I guess what I need to know is, who do I need to send this to for review and modifications? Who should be my point of contact?
Who is responding to the ad, Jan or your department? Like if someone says, yes, I'd like to apply, who is getting the information?
That's up to you guys. If you want Jan to receive those, that's fine. If you want me to take them, I can take them. It's entirely up to you guys. Yeah.
I would be okay, Jan, unless you're worried that too many will come in during renewal season.
We could play it and see. If anything, I can tell you that when I was hired, I had a phone interview with Penny, my predecessor, and then I had an in-person interview. I think it was with Jean Kloftenstein, who was the secretary treasurer, and I think Lois Churchill, the public member, was on the phone when I had my interviews. And so those were the two board members plus Penny when I had that sat in on the interviews. Okay. So if that helps.
Yes.
Okay. And so then once you have somebody selected, then we will send their name and the salary and the start date to the governor's office, and they will make the final approval and send us back a letter saying, yay, it's official. You can appoint this person. So there is a tax clearance request form that needs to be filled out for a certification through the Department of Revenue for the actual person that's being selected. But that's all part of the process, and applicants typically know that as they're coming and trying to apply for state jobs. And if not, we'll walk them through it.
Isn't the tax clearance required before they can even apply?
No. Nope. No. We just have to have it now. They changed that, Jan. I'm sorry.
Well,
they changed that
how long
just
it's been.
The person. Well, exactly. You don't do this all the time. So yeah, we changed it to just one person. The person that's actually being selected has to have it in place within 10 days of hire. So, yep. I'm trying to think what else you might be thinking about. I have a position description.
Which I posted that online for them to look at.
Good.
Yeah, because that was identical pretty much to the one that I had when I started.
Yeah, so you didn't make any changes then, or?
No.
Okay.
Other than the last one I sent you.
For your increase, yeah. And I think that's what this one is that I'm showing you now.
Yeah.
So we would use that then to actually prepare the posting so that whoever is applying will have an idea of what the job is all about. And then we can help get them onboarded once they've been selected and vetted with everybody. So.
All right. Well, thank you for joining us.
Sure, absolutely.
Yeah, thanks for hanging out.
So I can unshare now, right?
Does anyone else have any questions? All right. Well, thank you, Ms. Conklin.
You're very welcome. Can you still see my
Thanks,
screen? Or
Allison.
Yeah.
No.
No. No.
I think I did it a couple times because I can't see the button at the very bottom. It won't scroll up for some reason. Weird, oddly enough. Okay, so if I'm off, then I will. Let me give you my email address, and that's Allison ALLISON .Conklin CONKLIN at ks.gov. Or you're certainly welcome to call me. My desk number is 785-296-8193. Happy to help. Whatever questions you have, because I'm sure you'll have some after we get off of here. You'll think of things, and that's fine. Just shoot them at me, and I'm happy to help any way I can.
All right.
Okay. Thanks for having
Allison.
me. Yep. I'll go ahead and log out unless you want me to stay.
No, I think you're good.
Okay. All right. Thank you all. Have a good day.
And so for board members, we do not have to make a decision today. I think it is extraordinary that we're only paying $400 a month for rent. I think in this day and age, that is definitely going away. I also think that Jan has done a really good job of consolidating and getting everything to archives. So she has very little actual physical paperwork that she has to keep track of. And so long term, I think we just have to consider, would we like to get Jan in an office that's already existing? I should say Jan's position. So for example, if we were to share office space with the Board of Dentistry, then when Jan is out, there is at least someone else there to answer the phone. Are we okay with this being a remote job, which would save us a substantial amount with rent in the future? So these are all things I just think we should think about when we are ready to discuss this, when we're interviewing people. Do you have anything to add to that, Jan?
And like I said, I can start putting out feelers with facilities because state office buildings, the rent is based on square footage of the office space. And basically we would just need a cube because, granted right now I have my desk, which could, and then the computer, 2 monitors, a printer, a scanner, and a file cabinet that's basically just storage. And so I would not need a whole lot of space. So, and that, when I did the budget for moving to Topeka, I did it based on my square footage on this current office, which we don't really need as much office as what I've got right now. So, and that putting feelers out to facilities could help figure out how much it would actually cost us to have an office in Topeka.
I think that would be a good idea.
The only thing I would have a problem with, like you mentioned the dental a minute ago, that gives more the perception of maybe you ought to become a super board. I think we need our own office, however that ends up being. Maybe we move it, but I just have an issue with combining like with the dental board because it just gives that perception of a super board.
Noted.
Yeah. So it'd be okay if I shared a space with like the real estate commission then, because they're not, because well, like I said, we're not looking at a very big space. And I think at one time Penny told me that they wanted to clump us in with mortuary arts at one time. So, and how they came up with us in mortuary arts, she had no clue, but there was at one time a big push to move all the offices to Topeka, to downtown, to an office building downtown Topeka. So, but I can, like I said, I can get with facilities and see what they've got available, just for look-see, because it doesn't hurt to look. And some of them like not mortuary arts, pharmacy and Board of Healing Arts, they're in what they call the old bank building downtown. They're not in a state building. There are some agencies that are in the Jayhawk Tower downtown Topeka that are, it's not a state building. So there are other options and for not having being in a state building. But
I am curious if our candidacy for applicants would be more broad if we knew up front if the job would be remote, as opposed to, locals. Just putting that out there. So,
yeah. But then with it being remote, then you've got the whole issue of mail. The mail going to go to.
Sure.
Can we just get a PO
then,
box that wherever the person is?
Well, okay, and then okay, people come in. The reciprocities come in to take the exam. We need a spot for them, which I'm sure we could find a spot. Like public library comes to mind because usually they have little pod places that we could use to give an exam, or state office building to give exams. But yeah, we could get a PO box.
I might just a thought I'm having, going back to what Dr. Beaver suggested, like the concern about sharing space with another board. I almost think that putting it under a remote location makes us easy to, evaporate rather than combine with other board. I just think when you're looking at perception and, the concern, I'm almost more concerned about not having a location than sharing one with another, another licensing.
Sure. I just know when it comes to taking these forward, whenever you mention that you're saving money is a big win. So
now,
yes.
but I think to Gary's point, if you've eliminated the need for a physical space, then are you sort of, saying to the public, it doesn't take that much to regulate optometry, which we all know that it does.
Sure.
But are you creating a perception by being easy for the budget office to get along with? Are you creating the perception that you don't have value as a board, which we do?
Sure.
Yeah. And that's been a perception for a long time, that people think I work remote, I work from home. And it's like, no, I actually have an office. But
So those are some good points that we'll think about, that will come full circle.
Yeah.
And then, Jan, do you have anything else to cover in your section?
No, that's it. Newsletter topics, but I've got a couple of suggestions. The trade names back in the newsletter, telling people they need to let me know who's working at one office when, because some of them they move around so much it's hard to tell, and they're not very good at keeping the database updated, because they look at it every 2 years, and a lot of them just skip to the payment part.
I don't think it would hurt to include our change in CE as well, because I think you're still getting lots of phone calls.
Yeah.
About in-person versus virtual and how many hours are required.
Yep. And then the DEA. Yeah. And the, what is it? The synchronous and non-synchronous CE. Is that the new terminology ARBA's using that's confusing everybody? Yeah. But yeah, and then I was going to have a little blurb about me being retiring. Everybody can. But I'm hoping that we actually have some good quality candidates. Accountancy took them forever before they found someone, and they just found someone, I think last month started, and she was going to retire in August. And now I think she's officially retired as of December 31st. But it took them a long time to find someone. So I'm hoping we don't have that issue.
That was going to be my concern about why I think work from home helps, right? Just sometimes finding people.
Yeah. And I do it 1 day a week only because my carpooler doesn't work on Fridays, so I don't drive in on Fridays. Otherwise, I'd probably be here 5 days a week. And I can tell you now, I'm kind of burning some vacation time by not working Fridays. Just as an FYI. And since how we're bringing it up, and I won't be in the office tomorrow because it's the National Day of Mourning for President Carter, so the offices are closed. So, and the other thing, budget. I just got a notification that the General Budget Committee will be meeting January 31st to hear our budget. And it may not hurt if one of you could either pop over to Topeka or have the link, so in case they've got questions about our budget or want to talk to somebody other than me that's going to say, oh, you don't want me to, I'm just going to agree with them. I don't care. So just as an FYI that I just got an email from KLRD that said the first budget hearing is going to be January 31st. Don't have time yet, but the fact that I've got 3 weeks notice is amazing. Usually it's maybe a week.
And do you have a time frame? Will that be morning or afternoon?
I'm thinking if it's general budget, I'm thinking they usually meet in the afternoon, like around 3:30 in the afternoon. But you can also, it'll be through WebEx, and so you can attend virtually as well.
Okay.
So you wouldn't have to come to Topeka if you didn't want to. But I'm thinking it might be a good idea if one of you at least attended.
I might be able to swing that. I'm on call that week, which just means I do have to be local. But if you could get me a time for the meeting, I can confirm that.
Yeah, I don't know if they have time out there yet or not. It's just it's tentatively scheduled for January 31st. And I'm thinking that the House General Budget Committee usually meets in the afternoon.
Okay.
That's how they've always done it previously, I should say. Not saying that they would do it this year. Things change from year to year.
Looks like it may be at 3:30.
Yeah. But I'm hoping the governor's budget report should be out, I think, next week. The governor's budget recommendation should be out next week. And hopefully she leaves us alone. And if she leaves us alone and budget left us alone, that maybe there won't be that big of a deal going through the budget.
Okay. I'm assuming we are going to table the regulation update / review. And then do I have any comments from the public at this time?
Fine.
Todd was on earlier. I don't know if he's still there.
I'm not seeing him listed.
Okay. Any other concerns? Overall, I was really looking forward to our board member training, which Jan put a lot of work into organizing. So ideally, we will add that to our next meeting. And then do we want to look at dates for the next meeting? And Todd reports no comments.
I've got something I wanted to add. I don't know if now's the time in the meeting to suggest content for future meetings.
Okay.
But, in light of the changes in Part 3 of the national boards, we maybe should at least discuss what we plan to do moving forward about our boards. I know we talked about it last summer when we approved our new licensees. But
I agree. I'm hoping by our next meeting, we actually have a good handful of scores that are coming in. And part of our board training was going to include some of the discrepancies and some of the things statistically that we can look at, kind of how to read the scores. So I will add that to the agenda for next meeting.
thank you.
What month are you thinking about for our next meeting?
Does April work?
I think so, for me.
I'm open to days if anyone just wants to.
How about April 9th?
That works for me.
Looks fine for me.
I have a court hearing at 9 o'clock that morning, but that's my only. It's a Zoom hearing. That's my only conflict.
So would you rather do the 16th?
Would the
I
intent be?
can't do the 16th. That'd be really hard for me.
This would be an in-person meeting in the Capitol.
Yes.
You know, I don't know when. We usually shoot for the April break, right, Jan? As far as when the legislature breaks, and I don't know when that is. That way, there's a meeting room available.
Jan, you're muted.
Oh, sorry. Yeah. I can wait for the legislature calendar to come out, and then I can do it like a doodle poll to see which dates would work. If you guys want to wait, that way we can get the Capitol.
Yeah, I think that'd be a good idea.
When do the dates come out, out of curiosity?
Should be out hopefully next week.
Okay.
Session starts Monday, so sometime next week.
And then would you
So will
agree,
we
Jan,
schedule
we
board
usually
members?
have one Zoom meeting prior to the July meeting? We'll have our April meeting
Right.
and then one more. Okay.
Yeah. Yeah. And if you guys want, I do have one MBO score that I just received yesterday that has the new PIPS score on it, the new part 3. If you want to partake, I don't, it's the only thing I have on this person is their MBO scores. But
I wouldn't mind. Can you post that on the board member page just so we can look at the new
probably
results?
ought not.
Okay.
Let me email it to you.
Okay.
Yeah. I'm not sure how secure that the website is, so it'd be better to email it to you or send you a link to the file.
Yep, that'd be great.
Yeah, that way you can at least see it.
Even if it was masked.
So Tim, you're still on here?
Yes, I'm here.
So I don't know whether, I think probably you and I could just have a conversation later, or maybe we need executive session. I sent you a consumer complaint through Jan a while back that I wanted you to look at. Do you recall seeing anything that you would have had like that about? Okay. So is that a me talk, or is that a executive session talk?
Yeah. No, you and I will talk.
Okay.
We can couple that with the other issue that we're going to work on, the response to JCAR.
That works.
All right. Any other follow-up information?
Just so you guys know, for meeting planning purposes, I will be unavailable the first 3 weeks of February. I can give you details privately about that. I'd rather not announce it in a public meeting, but I won't be able. I may have email correspondence, but I wouldn't be available for that time period, which you guys should still have a quorum and be able to do things without me during that time. But I wanted to give you a heads up on that. Sorry.
That's good. And then maybe just put in your calendars, the ARBO meeting this year is June 22nd, 23rd, usually only a half day on the 24th. I highly encourage everyone to go, and you do not get any CE credit for attending, but although I have often not looked forward to the meeting, I have always left feeling like it was a very good meeting and I had learned a lot.
Would you give me those dates one more time?
June 22nd through the 24th.
And it's in Minnesota, right? Minneapolis.
Yep.
They do offer scholarships if anyone has any concerns, or if Jan's budget doesn't allow all of us to go.
I scrimp and save all year round just to make sure that I can send everybody that wants to go, and I try to put it in the budget anyway. But I hate the timing of it because it's right at year end, so I always try to make sure that I have money to go to send everybody that wants to go. And there is an ARBO meeting next week too. One of their happy hour meetings next week too. If anybody's interested in attending it, I think it's next Tuesday.
I believe they will go over a Supreme Court decision that will affect how we make decisions moving forward. So it should be an interesting one.
Yeah.
Yeah, that's about the Chevron being overturned.
Yep.
That's actually been the law in Kansas for 50 plus years, that agencies aren't afforded discretion. So Kansas has been there for quite some time.
Okay.
It's a big impact federally.
And they usually post the video, so if you can't watch it live, I'll get the video posted for you.
Any other concerns or business that needs to be discussed? Would anyone like to make a motion?
Sorry, did we pick a date for our next meeting in April?
Jan's going to send you a doodle poll.
When I know the legislature dates.
I make a motion to adjourn. Dang it. I make a motion to adjourn the meeting.
Do I have a second?
Second.
All in favor say aye.
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 Opposed, same sign. All right. Well, thank you everyone for attending. I think we got a lot done, and Jan will be in touch with our next meeting.
Are we aiming for board training on that meeting as well?
Yes, that is the goal, depending on our, we had quite a crew coming in for the meeting, so
okay.
Ideally, yes.
Hopefully no bad weather, no blizzards.
Yeah.
All right, good to see you guys.
Thanks.
Bye.
Bye.